Hello everyone, welcome to IES Baba, the daily initiative of PYQ solving. In this particular series of PYQ, I'll be taking the polity part. In the polity part, I have divided all the PYQs for the past 10 years into various themes so that it is easy for you to understand that from what particular topic or from which particular topic, what sort of question can be framed. Already we have done two series, that is the question which can be framed from the directive principle of state policy and also from the terms and terminology. Now let's start with the third lecture or the third discussion in this particular series. That is nothing but the Indian judiciary, right? So the first question that has been asked in 2024, the recent question of the 2024 from the Indian judiciary was asked on the writ of prohibition. Please remember that it is important for you to remember all the writs of the fundamental right. Writ is nothing but the order that can be issued by the Supreme Court or High Court in order to uphold your fundamental right. In case of any violation of the fundamental right, you can directly approach the Supreme Court or in some cases to the High Court, and you can demand the justice from the Indian judiciary. Now this order is called as writ in legal language. Now there are 5 types of writ that I expect you to please go and revise all the 5 types of writ. Again, the question was asked in 2024. Same question can be framed even in 2025 prelims. Now let's try to understand the question. That a writ of prohibition is an order issued by the Supreme Court or High Court to a government officer prohibiting him from taking a particular action. The Parliament or Legislative Assembly to pass a law on prohibition. Again, statement is not making sense. Prohibition is not talking about or giving direction to the Legislative Assembly or Parliament to make a law. Is it clear? Then the lower prohibiting continuation of proceeding in a case. The lower court prohibiting continuation of proceeding in a case. And the last is the government prohibiting it from the following an unconstitutional policy. Again, D cannot be the exact answer because it is not talking about the government prohibiting it from following an unconstitutional policy. Right? This is not the meaning of writ of prohibition. So the correct answer is C, that the lower court should be prohibited if they are exceeding from their particular jurisdiction or if they are making any judgment on a particular case in which they do not have any power. A writ of prohibition is basically given to the lower courts in case they are exceeding their jurisdiction or in case they do not have the power to give judgment on a particular case. For example, in federal dispute, only the higher judiciary in India can give the judgment, that is Supreme Court. So if any lower court is trying to exceed from their jurisdiction or if they don't have any power to give the judgment on a particular subject, again the writ of prohibition can be issued to the lower courts. So the correct answer is option number C. In 2022, the question was asked, right? A very interesting question. Let's try to understand it. With reference to India, consider the following statement. Now, the first statement is saying that government law officers and legal firms are recognized as advocate. That government law officer and legal firms are recognized as advocate. But corporate lawyers and patent attorneys, they are excluded from the recognition as advocate. Now, this particular statement is not making any sense. If you are having a little of common sense, then you must be knowing that anyone who completes his or her law degree, then that person is called as lawyer. But whenever that person is, going for the practice, either in the government law offices, either in the legal firm, either in the corporate setup or even under the attorney, right? Or either under the patent attorney. Anyone who is practicing law is called as advocate. So this particular statement is incorrect. Right? Now, second statement is saying that Bar Council have the power to lay down the rules relating to legal education and recognition of law colleges. Now, this particular statement is correct because in India, it is the power of the Bar Council that they are having the power to decide upon the syllabus, to decide upon the examination method, and also the recognition of law colleges. It is the power of Bar Council. So, the option number 2 or B statement is correct. If you know the statement 2, well and good, but while reading the first statement, it should click your mind immediately that this is incorrect. Right? Now, let's come to question that was asked in 2021. With reference to Indian judiciary, consider the following statement. First statement is saying that any retired judge of the Supreme Court of India can be called back to act as a Supreme Court judge by the Chief Justice of India. So, while reading the Supreme Court chapter, you must have heard about the retired judges, the additional judges and the ad hoc judges in the Supreme Court. Now, the question has been framed from the similar retired judge. Now, a retired judge, after completing the age of 65 years or after the completion of tenure, they can be called back to sit back in the Supreme Court if there is increase in the pendency of the cases. Right? So, this particular statement is correct. Now, second statement is saying that a High Court in India has the power to review its own judgment just like the Supreme Court does. Now, review its own judgment, the answer is correct because High Court in India, they are having the power to review their own judgment just like the Supreme Court is having the power to review their own judgment. So, both the statement is correct and the option that is both 1 and 2 is correct from this particular question. Now, in 2020, the question was asked, consider the following statement that Constitution of India define its basic structure. While reading this particular statement till here, you should be stopping and you should be remembering the Keshwananda Bharati case under which the Supreme Court gave the particular innovative principle or innovative doctrine of basic structure. So, this is an innovative principle which has been propounded by the Supreme Court and nowhere it has been used in the Constitution of India. If you have read polity in detail, then you must be knowing that basic structure doctrine is trying to give extra powers to the Indian judiciary. Is it clear? And also, it is trying to save the Indian democracy whenever any law is made by the Parliament which is arbitrary in nature. Supreme Court, by using this particular doctrine, is saying that it is against the basic structure, basic philosophy of the Indian Constitution. So, while reading this particular statement, you should be stopping here and mark it incorrect because the Constitution of India never defined the term basic structure. It is the innovative solution which has been provided by the Supreme Court and not the Constitution of India. Now, second statement again is saying that Constitution of India provides for judicial review, right? Constitution of India, yes, it provides for judicial review, but it does not explicitly provides for judicial review. Please try to understand the meaning here. It is saying that, for example, in India we are having federal system, but the word federalism has nowhere been used. In India, sometimes the central government becomes more powerful on the state government. Again, the word unitary system is nowhere used. So, just like that, Article 32 of the Indian Constitution and 13 and so many other articles which is providing us for the judicial review, but the Constitution explicitly is not talking about the judicial review. So, again, making this particular statement as incorrect, right? So, please remember that what is given in the Constitution and what is not given in the Constitution, because many a time UPSC tries to trick you over certain things like this, right? So, don't get tricked by the UPSC because in Indian Constitution, neither the term basic structure is defined and neither the term judicial review is explicitly given. So the correct answer is neither 1 nor 2.